Welcome, students. We are going to talk today specifically about how environmental policy is shaped by that third branch of the federal government, the court system, the judiciary. We've looked pretty extensively already at how the president and the executive branch influence environmental policy, how Congress influences environmental policy, and now we're going to look at that third branch. I think this one will be a little bit shorter than the others. So first of all, a look at the United States judiciary system and how it functions. This is on the federal level. So of course, at the very top, we have the United States Supreme Court. On the federal level, we see this branch over here on the left, where underneath the U.S. Supreme Court are the federal circuit courts. And there are 13 of those, and they're organized geographically into different districts. And then underneath the federal circuit courts are what are called district courts. There are 94 of those that, again, even narrow down more specific geographically as well. And so any federal cases typically start in the federal district court. And they can, from there, be appealed up to the circuit courts, and from there, they can appeal up to the Supreme Court. Though with each successive level you go up, fewer and fewer cases are heard. So many cases, once they're decided at a lower court, simply stay in that decision unless the court above it decides to take up the case and to hear it. On the right, we see how state courts are organized, beginning at the bottom with county or state trial courts, which is where most state legal issues begin. And then we have a court of appeals. We have state Supreme Courts. And then, of course, plaintiffs can appeal above the state Supreme Court to the United States Supreme Court. The United States Supreme Court is the sort of supreme law of the land. Whatever the Supreme Court decides is settled law unless a new legislative statute passes and is signed into law. Though, of course, the Supreme Court or the court system can still declare those laws unconstitutional. But this is the makeup of how that works. Things begin at the bottom. They work their way up if they are appealed and if the court above it decides to hear the case. Federal judges are nominated by the president and confirmed by the Senate, and this nearly always follows party lines. So if the president's party is in power in the Senate, they nearly always confirm the president's choices. If the opposing party is in power, they still have to confirm some judges, but they are much more picky about that. Now simple majority vote is required. For many years. This was subject to the filibuster, and that resulted in sort of more moderate, more mainstream judges being nominated and confirmed into their positions, while Democrats changed the rules about the filibuster for most presidential nominations during the Obama years. They kept in place the filibuster for the Supreme Court, and that was largely because they were frustrated at how much Republicans were basically failing to nominate, or failing to confirm Obama's picks. So the Republicans were holding up Obama's choices for the judiciary. The Democratic leaders in the Senate decided to do away with the filibuster for judges. Republicans later, under the first Trump administration, changed the rule also for Supreme Court nominations. So now all federal judges, including Supreme Court judges, are approved by simple majority vote. You can see the numbers there. By the way, there's nothing in the Constitution that states there must be 9 Supreme Court judges. That has been tradition. And so far, that has been tradition that has never been broken. I shouldn't say never. I'm not a historian, but certainly not in modern times. And then we see circuit and district court judges as well. Also, these are appointed for life. Once a judge has been confirmed by the Senate, they are in there until they die or until they retire. And the political theory behind this is that it protects them from partisan pressures. So the idea being, we want judges And I think most of us really agree with this, that we want judges to be as nonpartisan as possible, as open-minded as possible, as um, yeah, nonpartisan. And by making it so that they are untouchable except for, certain, they can be impeached and removed from office, but as you've seen, and probably in your lifetime, that's a high bar, and it's difficult to do that. And it really needs to be something particularly egregious. So in theory, the lifetime appointment is helpful in that it protects them from partisan leanings. It My personal take is that combining the lifetime appointment with the simple majority vote, I think, is a bad combination because now it makes it much easier for either side, the right or the left, to get highly ideologically leaning judges into play because all they need is a simple majority in the Senate, and then those people are in there for life. So I don't think it necessarily plays well to democracy to have simple majority vote to confirm judges and lifetime appointment for judges. I think if you were to change just one of those, it would be a little bit more fair, a little bit more democratic. That's just my personal opinion or thought on that. Nevertheless, this is the system as the way it is right now, and how it works. This is just geographically looking at how the federal circuit courts are made up. As you can see, there are different regions, locations, and this just kind of like highlights in red and blue sort of the ideological leaning of those particular courts at the moment. Um, Actually, this is as of a year ago. I haven't updated this slide since then. I don't know if it has changed. Certainly, it would have changed somewhat. As you can see, there are certain circuit courts that tend to lean conservative and certain ones that tend to lean more liberal. And that's simply because those enough of those positions were open during a friendly presidency that they were able to get enough judges in there to lean that way. Now, where this is important, well, a couple ways. One, circuit courts are very important because the Supreme Court only hears a very small number of cases each year. There's only 9 justices on there. They have a very limited capacity for what cases they can hear, and so they're very picky. So most decisions of the circuit court stand as the law of the land. They aren't changed, and so it's really important, who circuit court judges have significant influence. It's also important in that think about strategically, and we talked in the last session about how critically important it is in terms of like with all of this bipartisan swinging one way and another, and the way we're seeing kind of like more extreme polarization, and then particularly in the last year of President Trump really flouting a lot of the norms and rules on how the system works, to the extent of even doing things that are blatantly against the law in order to hold presidents accountable when they do that, or in order to fight back against or try to mitigate some of these extreme swings either direction. The only tool that people have or that decision makers have is to use the court system. Well, I mean, you could use Congress to do that, but as we've talked about, Congress is so dysfunctional and so difficult to get anything meaningful passed there that the court system is really where we're seeing a lot of people rely on to make that happen. So the ideological leaning, particularly once you get up to the federal circuit court letter, is really important. And parties use that very strategically. So if you're like a major environmental nonprofit organization and you're trying to bring lawsuit against the federal government, um, and you have choices of where to, what plaintiff to choose, you're going to pick one in New York rather than one in Kentucky because New York is located in a circuit court that ideologically leans more liberal versus Kentucky is in a circuit court that ideologically leans more conservative. So you're going to pick one that's a little bit more friendly to what you're trying to do, and vice versa. So both sides really strategically use. They often bring cases forward in the circuit. You can't just bring a case forward in any circuit court. There has to be. Honestly, I don't know the guidelines around how that works, but there has to be some sort of standing in that geographic region to do so. But often, when bringing cases before the courts, they have some options. The Supreme Court governs by majority opinion. So 9 justices, if 5 of them agree, then that becomes law. Uh, Anytime judicial opinion is joined by more than half the court. Supreme Court hears fewer than 100 cases a year, so most cases never get here. So the majority opinion, that's the opinion of the majority of the justices who decide on a particular case, 5 out of 9. Sometimes it may be less than 5, sometimes maybe one may recuse themselves for whatever reason, but typically that would be at least 5 out of 9. Sometimes, let me skip down to the bottom one, dissenting opinion. Those are the justices who disagree with the majority opinion, and they want to explain why. And it's not just because they want their voice heard. Often, so in future decisions will take into account dissenting opinions or concurring opinions in terms of how they rule on them as well. And it's really important in dissenting opinions for the justices to explain the legal reasons why they disagree with that. That sometimes helps further down the road, and it may be never, or it may be years from now, but often those dissenting opinions are used later on if a later court decides to revisit the question. And this has happened, and we'll talk about a specific example of how that's happened recently. A concurring opinion is a justice who agrees with the majority opinion but has a different rationale for doing so. Sometimes you may see the majority opinion having fewer than 5 votes. Maybe let's say there's 4 justices in the majority opinion and 4 in the dissenting opinion, but 1 justice has a concurring opinion. That means that they are casting their vote with those of the majority, but they're going to issue a separate explanation for why. And that also can be used for future decision making by the courts in terms of how they weigh decisions as well. So that's important. One of the most important legislative statutes that impacts how the court functions came in 1946, called the Administrative Procedure Act. And this is really critically important for everything of how the executive branch functions, too. Basically, what this act does, it tells us how the executive branch does what they do, how they make rules, how they establish regulations. It sets in place the very specific processes and principles and mechanics of how the executive branch functions, how regulations are put forth. What does the process of look like that? That includes things like requiring that public notice be given, that public comments be taken, et cetera. So this is a very specific, one of the most important pieces of administrative law. Some scholars refer to it as the Constitution of Administrative Law. This is basically sets the foundation of how administrative law works. Administrative law referring to particularly how the executive branch issues rules and regulations and governs from the executive branch. So this is very important. Notably, related to the judicial branch, the APA grants federal courts the power to have oversight over agency actions. In other words, this states that the judiciary not only has the power over legislative statutes, but they have power over executive actions, regulations put forth by the executive branch, rules that the executive branch installs, decisions, any kind of administrative actions or decisions by the executive branch. The courts have power over that. They can overturn an agency rule or a regulation, but they have specific standards by which they must do that. So, for example, in order to overturn an executive, the courts just can't overturn it for fun. But if they determine it to be, quote, arbitrary and capricious, in other words, if the executive branch hasn't done its due diligence of following the right procedures, if they haven't done their due diligence, if they haven't followed it the right way, the courts can strike it down. This happens a lot with the Trump administration because he does act in a very arbitrary and capricious manner, as you no doubt see for many examples of how he governs. It's very much, he makes a sudden decision, he puts his full weight behind that decision and expects the executive branch and those who work for him to immediately implement that decision. Well, the Administrative Procedures Act requires governing to happen in a certain way, requires regulations to be put forth in a certain way. And it's a bit tedious and it takes time. Often this takes a year or two or more in order from the initial proclamation of an idea to actual implementation of a regulation. It takes a lot of time. And if the executive agency doesn't follow the correct steps, then the court system can determine that they acted in an arbitrary and capricious manner and strike down what they did. Um, and often it doesn't have even as much to do with the what of it, the regulation. The regulation may be perfectly fine and legal, but if the manner in which it was done didn't follow the correct procedures as set forward in the APA, then the courts can reject it and strike it down. And that tends to happen a lot with Trump because he doesn't. His first time he was worse at this in terms of just really putting things out there without following the proper protocols. His administration is a little more competent in terms of following those protocols now, but we still see this happening. And yeah. Can also overturn regulations if it's determined that the executive agency has exceeded their statutory authority. And this has happened a number of times lately, particularly around environmental policy, where a more conservative leaning Supreme Court will state that certain actions by the executive branch from previous administrations, from Biden or Obama particularly, exceeded their statutory authority. We don't see that arbitrary and capricious as much with, say, Biden and Obama as we see with Trump, but we do see a lot more of striking down orders on the claim that they exceeded their statutory authority. And that all goes back to what we talked about in the legislative area of we've got these really old laws around environmental governance, and they don't deal well with modern environmental challenges. And so more left-leaning presidents have tried to use those and shape those clunky instruments into a way that they can use them to address more modern environmental challenges. And some of the courts, particularly now with a more conservative leaning court, are saying, no, that exceeds the statutory authority. That original law from 1970 wasn't totally clear on that, so you can't actually use it in that manner. And right or wrong, that's completely within the purview of what the courts can do. They are able to determine whether agencies are exceeding their statutory authority. And to be fair to the courts, a lot of these statutes, as we talked about, are really ambiguous and unclear on some of the ways they're trying to be implemented. We'll get to more specifics here in this lecture and again in a couple of days as well. Looking historically on how environmental policy was done in the courts, before the 1970s, we simply didn't have a lot of legislation to address environmental problems on the federal level. Not that there was none, but it wasn't really particularly widespread. We didn't have a lot of comprehensive, really didn't have any comprehensive federal policy around environmental issues. And so environmental concerns around pollution, they tended to be addressed within the courts prior to the 1970s. We didn't have legislation, we didn't have statutes in place, we didn't have the EPA before 1970. A lot of the federal efforts around this happened in the courts. Your book gives an example of the state of Missouri suing the state of Illinois for wastewater pollution from the Chicago wastewater that is flowing downstream. And the courts ultimately denied Missouri's petition there. They just didn't have the science back then to really be able to demonstrate the health impacts. But that was how these were handled in the past, was through the courts. Now, starting in around 1970, we got a lot more environmental legislation passed. We got a lot, as we've talked about, a lot of environmental policy put into place with this new statutory legislation, the Clean Air Act, Clean Water Act, Endangered Species Act, NEPA, a bunch of other things. Executive agencies now have the legal authority to enforce environmental regulations. So it's not all on the courts like it was before. Now, these executive agencies, they have statutory authority. They have executive agencies. They have the weight of law behind taking actions on that. And so now the federal government has a much stronger position in terms of regulating environmental pollution. since the 1970s. We are now in the process of kind of swinging back the other way again. And this just goes back to what we say so many times in this class. We've got new and complicated environmental problems. We've got really old, clunky laws that are out of date. We've got extreme partisanship and gridlock in Congress. All of this plays up to the courts are playing an increasingly larger role in shaping environmental policy today. The executive branch keeps swinging one way or the other. Legislative branch is not passing new stuff, hardly at all, on environmental policy. And so a lot of these things are being settled in the courts again today, simply because there's not any kind of, the structures within the other two branches of government are not today set up well to deal with the kinds of problems we have. So the courts are left to deal with it. There's, of course, limitations to what the courts can do. The biggest limitation being courts are passive institutions. The courts can't go out and seek policy changes. They can't proactively, it's the opposite of Congress in that sense. Congress can come up with any idea they want, write it down, vote on it, and pass it into law, no matter how ridiculous it may be, no matter what the topic is, no matter if it's the complete opposite of something that was done last year. Courts can do what they can initiate whatever they want. Sorry, strike that. Congress can initiate whatever they want. The courts can't initiate anything until it's brought to the courts. They're passive institutions. They only react to cases. Now, justices or judges, they can give hints, opinions, give speeches, and they often do those kinds of things so that people kind of maybe know their leanings. But they can only respond once a case is brought before them. There are also frequently conflicting outcomes between multiple courts. Maybe there's a federal court in California that decides one thing, and a federal court in New York that decides something different. Well, now we have kind of different principles in place. If the Supreme Court takes the case up, one of the cases up and hears it, then that could settle it. But if the Supreme Court doesn't do that, this is often the case, then we don't necessarily have fully settled legal principles around that. And also importantly, the courts have limited, really essentially no enforcement powers. If the federal court, even if the Supreme Court decides something, the courts have no military, they have no police, they have no physical means of actually enforcing that. Now, most of US history, this has not been a problem because our system has functioned as it, more or less, as it's supposed to. We have largely followed the norms of how our constitutional system has set up. That's eroding today. And part of the concern of how the Trump administration is working is simply around this neglect to the norms of how institutions function and operate. And so that has sometimes already been left where judicial decisions are simply being ignored. If you think back to the Supreme Court upheld the federal ban on TikTok. Did TikTok ever go away? It didn't, and because the Trump administration simply didn't implement that ban. They simply ignored it and waited it out, and nothing ever happened from that because the Supreme Court has no enforcement powers. Even though it was well over a year, it has been over a year of having that ban in place and affirmed by the Supreme Court, and yet nothing happened. So no enforcement powers from the courts. Now, the rest of this lecture, we're going to focus in on how does the court actually influence environmental policy, and particularly in 4 different ways. And the book talks through this. We're going to talk in more detail about some of those examples there and some other examples. But these are the 4 means of judicial influence. So first of all, forcing policy action. So the courts can force the government or other entities to take specific actions. So example number 1, Massachusetts versus the EPA. One of the most important environmental cases that has been decided. 2007, Basically, how this started, a group of environmental organizations petitioned the EPA that they needed to regulate greenhouse gases. This is back in 1999. The EPA at the time was not regulating greenhouse gases. And so the environmental group said the EPA needs to do this. We're recognizing climate change is a really big problem. We need to regulate greenhouse gases in order to prevent that. Well, the Bush EPA refused to do so. They said, nope, we're not going to do it. So Massachusetts and many other states and environmental groups sued the federal government to try to force them to regulate greenhouse gases, and the Supreme Court sided with Massachusetts. Specifically, they said the EPA has the authority to regulate and the responsibility to determine whether they cause or contribute to air pollution which may reasonably be anticipated to endanger public health or welfare. This is what's known as the endangerment finding. We're going to go into more detail about this in a couple of lectures from now. But the endangerment finding is one of the core principles of the Clean Air Act. And what the Clean Air Act says around this is that if there is a source of air pollution that causes danger, endangers public health or welfare, then the EPA must regulate that. So Supreme Court here is saying the EPA does have authority to regulate it if they determine it meets the endangerment finding. And the Supreme Court went further than that, said the EPA needs to make that determination. So the EPA has to take the issue up and decide whether it meets that danger to public health and welfare. Really critically important. Sorry, I was looking at my notes. I have an old note in there that's no longer relevant. Another attempt, and this one did not pass, so this is not law. The second one, Juliana versus United States, originally filed in 2015, 21 youth plaintiffs. And the argument here is that the United States' failure to effectively address climate change is taking away their constitutional right of life, liberty, and property by damaging the world and through the changes that the climate that greenhouse gas emissions are causing to the climate and harming their constitutional rights there. So say that there's an obligation to hold certain natural resources in trust for the people and for future generations. That public trust principle is the idea that the government holds in trust certain things for the good of the people, and that the government's failure to effectively regulate greenhouse gases is a breach of that trust, and thus an infringement on the due process rights of life, liberty, and property of young people everywhere. And look at these specific youth plaintiffs. The district court, that's the bottom one on the federal level. We got district, circuit, and then the Supreme. The district court agreed with this, but ultimately the circuit court rejected it, and the Supreme Court didn't take it up. The circuit court did say that the plaintiffs had standing, which means that they had a legal reason to sue, but they didn't go along with the argument and reject it down. But that was an attempt to force action, right? It didn't happen in the end because it was rejected. But what Juliana versus the United States is trying to do, it's trying to force the federal government to do more to address climate change. So this is like trying to force certain action. So this forced policy action often attempted to be used by environmental groups to get the government to do more. Another tool is to delay policy action. Executive orders attempting to change existing rules without going through APA process are likely to be deemed arbitrary and capricious. We talked about this already. How if a president, if an executive branch tries to make new rules, tries to undo old rules or to make new ones without going through the correct process, then that's a breach of the APA, Administrative Procedures Act. So whenever that happens, and we've seen that happen a lot lately, as I just said, environmental groups, states, concerned individuals, whatever, can sue the federal government in order to prevent that from happening by delaying that because under the arbitrary and capricious clause. So if it's not following the correct procedures of the APA, that's arbitrary and capricious. But the courts can't do anything on their own. Remember, courts are not proactive. They are only reactive. So no matter how obviously arbitrary and capricious this action is over here, the courts can't do anything until someone brings it to the courts as a case. That's why you have all these groups that say may sue the federal government for saying, undoing that pollution law from the previous administration or that regulation on methane from the previous administration, undoing that, the way you did that was arbitrary and capricious. We're going to sue you, bring you in court. It's going to take it to the court system, and then the courts can delay that policy action or completely block that policy action from happening, if it fits the right criteria. So we've seen that a lot lately. Another example from your book, California versus the U.S. BLM, Bureau of Land Management. Now, under Obama, the BLM issued regulations restricting methane venting, flaring, leaking during oil and gas production on federal lands. So, of course, the Department of Interior was interested in having more pro-environmental positions. So they had a bunch of restrictions around methane. Methane venting is basically, so methane's 30 times stronger than carbon dioxide at trapping heat. So it's really bad. Natural gas chemically is methane. Drilling for oil, there's a lot of methane in that. Methane venting is when the drilling company, has too much methane and they don't know what to do with it. And so they just vent it up to the atmosphere because methane's explosive. Rather than trying to capture it and use it, because methane is natural gas, it's actually a natural resource that's very valuable. Rather than trying to do that, maybe because it's too expensive, maybe because they're lazy, maybe for whatever reason, they vent it. Or flare it, which is where they vent it but burn it, which is better than venting because when it burns, it turns to carbon dioxide chemically. That's better than methane, still bad. Either way, that's what venting is. So the rule was challenged in Wyoming District Court. Sorry, I lost my train of thought. By the time the case came up, Obama's no longer in office. Now Trump's in office. The BLM gave notice that it was going to postpone compliance dates for this for new regulation. The Trump administration didn't want to implement that. They didn't like it, so they said, "You don't have to comply with this regulation about restricting venting." Now, remember, the regulation is the law right now, but the Trump administration is saying we're not going to enforce that. California and New Mexico sue the federal government to try to get them to what's called vacate the postponement. That just means you need to remove, to take away, to get rid of the postponement, saying you can't do that. You can't just not enforce something that is a legal on the books thing. The federal court, this was in California, agreed that the BLM couldn't postpone compliance. In other words, the Trump administration was trying to delay, trying to stop this action. Federal court says you can't do that. You have to, specifically, the BLM needed to give reasoned explanations. It kind of gets the arbitrary and capricious. You can't just do something because you want to. You have to give reasoned explanations and go through the right process for that. However, the next step, a federal court then in Wyoming stayed the implementation of the original regulation pending new BLM revision. So the BLM is now under a different president. They're actively working to write new regulations, and the federal court delayed the implementation of the original ones because the BLM now is writing new regulations. So it's all this complex, back around this way. If you followed all of that and how it works, good for you. Most of you probably didn't. It took me a while to follow that myself. Point being, all of this delays action. All of this bringing into the courts delays actually the implementation of all of these things. Third, shaping policy. Courts have the opportunity to shape policy. Another one of the most important environmental law cases, Chevron versus the NRDC from the 1980s. And The way this worked was, so the Clean Air Act instructs the EPA to regulate what's called source emissions. Source emissions being emissions that come from a specific point, like from a power plant, from a factory, etc. The EPA allows states to issue pollution permits that aggregate sources into groupings for sake of meeting these pollution reduction requirements. But the NRDC sued, saying that it wasn't a reasonable interpretation of source. Source isn't a grouping of sources. Source is a source uh, under the Clean Air Act. So that was kind of the principle around the Chevron case. And what came out of that, and this was a Supreme Court decision, and the Supreme Court at the time said that when language of a statute is unclear, which, as we know by now, happens a lot because we're looking at statutes that are really old and don't necessarily deal very clearly with modern challenges. So Chevron versus NRDC, the Supreme Court decision, if the statute's unclear, the courts should defer to the agency's interpretation as long as it is reasonable. This is referred to as the Chevron deference. And this was one of the most important cases in administrative law for decades. And it had significant impacts, as you can imagine, because that means that the courts, that limited the court's ability to change administrative decisions within the executive agency, because it said the courts have to defer to the executive agency unless they were unreasonable in terms of what they were doing. So it set up a clear preference for executive agency decision making. Now, one side will criticize that, saying that it gives too much power to the executive, not enough power to the courts, which are supposed to be a little more nonpartisan. And I think that's a good criticism. Another side will say, yeah, but executive agencies are largely staffed with experts in their field who really understand the content better and who are much better equipped than non-scientists in the judiciary to be able to address these complex scientific challenges. And I think that's a fair argument too. So one of the most important cases of administrative law, just 4 years ago, this was severely weakened by West Virginia versus the EPA, by which required that there was clear congressional authorization for this to be the case. So they didn't completely overturn with West Virginia Chevron deference, but what they did is they weakened it by saying that there needs to be clear congressional authorization around the agency's interpretation. So the courts no longer needed to defer entirely to agency expertise. This really overturned, in a lot of ways, decades of administrative law, puts power back in the courts. 2 years later, it was completely eliminated by Loper Bright versus Raimondo. All of these are Supreme Court cases right here. Loper Bright versus Raimondo, we're not going to get into the specifics of that. It's not necessarily relevant for what I want you to know. But basically, that said, when ambiguous, the courts need to determine Congress's intent, not the executive agency. So it completely took away the Chevron deference. So now, and remember back to my timeline, this is part of why we're seeing the courts having a much more significant influence on environmental law today, and really even much more significant just in the last 2 years because of Loper Bright case. So now the courts are to intervene when a law is ambiguous. Weyerhaeuser versus the United States Fish and Wildlife Service. This gets at the principle. So in the Endangered Species Act, the Endangered Species Act requires that the Fish and Wildlife Service protect what's called critical habitat for all endangered species. So there's a very strict regimen for protecting anything that can be designated as critical habitat for endangered species. Well, this is one case where there was a frog in the Louisiana area that Weyerhaeuser is a paper company. They were wanting to log an area. The area itself was not necessarily immediately conducive to habitat for this frog. However, the argument for the Fish and Wildlife Service was that with the way the climate is changing, that area could very soon be critical habitat for the frog. Well, the courts ruled that no, that the Fish and Wildlife Service went too far, that it has to actually be critical habitat today for that. So this is again a way that the courts are shaping policy. And so they're shaping the way the Endangered Species Act is interpreted. They're shaping the way that courts deal with ambiguity in statutes. So the ability to shape policy. And then lastly, constitutional review. Constitution prohibits the government from taking private property without just compensation. This is one example from your book, Lucas versus Carolina Coastal Council. Basically, you have a private landowner who is blocked by the state council from developing their parcel of land that was on coastal habitat that was deemed to be sort of fragile coastline area that needed to be protected. Um, and that landowner sued in court with the argument that their prohibition on him developing that land was effectively a taking of his land because it completely prevented him from any economic use of that land. And the US Supreme Court agreed with that and basically struck down that decision by the Carolina Coastal Councils that it was unconstitutional because it accounted for a taking of the land and stating that the owner must be compensated from that. Okay, a lot of different ways courts can influence policy. Key takeaways here: influence of the courts is increasing because of all of these things, because of this extreme polarization, because of recent court decisions, such as that Loper-Bright decision that made it so that no longer do the courts defer to agency expertise, but now the courts are the arbiters whenever there's ambiguity, and we know there's a lot of ambiguity in statutes. And just these extreme swings from one to the other, changes of administrations, it means that we're going to have a lot of fighting in the courts, and the courts playing an increasingly significant role in determining environmental policy.